Good morning to all. We at the Faculty of Law, Integral University, are proud to present the Interdisciplinary Faculty Development Program's Valedictory session. The month-long Interdisciplinary Faculty Development Program has been successfully culminated with the blessings of all the management and the blessings of obviously the Almighty God. We were able to culminate this event with the presence of the esteemed resource persons under the aegis of the Human Resource Development Center, Integral University as well. I, in the capacity of the HOD Faculty of Law and the convener of this faculty development program, invite all and welcome all the authorities of the Integral University, the patron of the FDP program, Professor Javed Musarrat, our respected Vice Chancellor, Sir, Dr. Naseem Ahmed, Dean, Faculty of Law, our chief guest of the event, Dr. G.K. Goswami, Director, UPSIFS, and the special guest of the event, Tabish Saroj, the legal consultant of the Tabish Saroj Associates Law Firm, New Delhi. I welcome you all in the valedictory session of the FDP. This present FDP has been successfully organized under the aegis of the HRDC Integral University, and it has been a month long from September 1st to September 30th on the theme Emerging Trends in Administration of Criminal Justice and Forensic Science. Our FDP has attracted an enthusiastic and diverse group of participants, including the faculty members, legal practitioners, and research scholars, with a total of 107 registrations. The journey began with the inaugural session on September 1st, 2023, where the entire event was graced by the presence of Professor Dr. Manoj Kumar, the director of the Indian Law Institute, New Delhi, as our chief guest. Dr. K. Pandey, sir, the associate professor at Dr. RML NLU, Lucknow, joined as the special guest, and obviously the Professor Javed Musarrat, sir, as the patron in chief, setting the stage for a month filled with insightful discussions and collaborative learning. Our FDP was thoughtfully structured into 3 modules, featuring a total of 18 technical sessions. These sessions were designed to offer participants a comprehensive understanding of the subject matter, encompassing various contemporary issues and challenges in the field of the criminal justice and forensic science. Renowned experts and practitioners, including Dr. Ghayasuddin Khan, Director of Forensic Science, UP, Professor Dr. Iqbal Hussain, Dean, Faculty of Law, Jamia Millia Islamia, Sergeant Manjeet Goyal from the Cyber Cell Port Division, Kolkata, Shri Jitendra Kumar Dwivedi, Deputy Director of the Northeastern Police Academy, Shillong, Meghalaya, Professor Dr. Deepa Dubey from Rajiv Gandhi School of Intellectual Property Law, Kharagpur, and many other eminent professors joining us from the NUJS Kolkata, from the Dean Faculty of Law, Delhi University, have shared and enriched the program with their insights and experiences. To ensure an active engagement and evaluation of the participants' progress, we conducted quizzes every weekend, allowing them to apply their knowledge. Feedback forms after each technical session encourage the participants to share their perspectives and suggestions, further enhancing the program's quality. As a token of appreciation for their active participation and successful completion of the FDP, all participants will receive e-certificates. Moreover, a letter of appreciation will be presented to our esteemed resource persons in recognition of their invaluable contributions. To extend the reach of knowledge dissemination, all technical sessions were live streamed and are now accessible on the Faculty of Law's YouTube channel, ensuring that the wealth of information which has been that the wealth of information shared during this program reaches a broader audience. Today, in our valedictory session, we are honored to have Dr. G.K. Goswami, sir, the ADG and the founder director of UP State Institute of Forensic Science, Lucknow, as our chief guest, along with Advocate Tabish Sarosh, sir, founder of Tabish Sarosh and Associates, New Delhi, as the special guest, and Professor Javed Musarrad, sir, who has graced the occasion as the patron in chief. And I extend my heartfelt thanks to all of them for dedicating their valuable time to our program. I would also like to acknowledge the outstanding leadership team that guided this FDP to success, including Professor Dr. Naseem Ahmed, Dean Integral University, and the conveners of this FDP, along with the co-conveners Dr. Mirza Junaid Beg and Advocate Tabish Sarosh, who have played a significant role in ensuring the program's success. The core committee comprised of all the professors of the Faculty of Law Integral University who have upheld the academic rigor and quality of the program the quality of the program. Their entire continuous efforts and the moderation of all the technical sessions have obviously contributed in the success of the FDP. I would like to express again to the student conveners, the special mention has to be made for them, the Qazi Muhammad Farhan, Zoya Hashmi, and Mustafa Faruqi for their unwavering commitment and enthusiasm. So this was the basic overview of the interdisciplinary faculty development program. This program has been an initiative in light of our new program, which had started and commenced in the Faculty of Law, the LLM 2 years criminal law under the criminal law and forensic science. So this FDP has also been an academic enrichment initiative in this regard. Without undue delay, now I would like to invite the Professor and Dean Faculty of Law, Dr. Naseem Ahmed, for a formal welcome of our guests of the valedictory session.
A very good morning to all present here today. I address you today with a profound sense of appreciation and accomplishment as we come together for the valedictory session of the 30 days faculty development program on emerging trends in administrative of criminal and forensic science organized by the Faculty of Law at Interdisciplinary University, Lucknow. I would like to thank our distinguished guests for the gracing this occasion with their presence. Professor Javed Musarrad sir, Honorable Vice Chancellor of Interdisciplinary University and the Chief Patron of this FDB, your unwavering support has been instrumental in the success of this program. We are honored to have you with us today. I also extend my warmest welcome to our chief guest, Dr. G.K. Goswami, ADG, Uttar Pradesh Police and Founder Director, UP State Institute of Forensic Science, Lucknow. Your presence here adds great significance to this event, and we are deeply grateful for your participation. My sincere appreciation goes to our esteemed special guest, Advocate Tabish, Director, Lloyd Forensic Institute, Noida, and Tabish Sarosh and Associates, Law Firm, Delhi. Mr. Tabish, who is associate with the Delhi Police and renowned expert in criminal investigation. I must acknowledge the tireless effort of the organizing team, the faculty members, the head of the department, Dr. Seema Siddiqui, and all those who have worked unitedly to make this program a reality. This FDP was conceived with a vision that forensic science would play an essential role in the evolving landscape of investigation and criminal justice administration. Looking back to last year, when we were in the process of developing a postgraduate program focused on criminal law and forensic science, it's remarkable to see how our initial vision has unfolded. We were pretty sure that bringing together criminal law and forensic science would make a big difference in the investigation field. When the government introduced a draft of new criminal law, it became evident that our program emphasizes on criminal law and forensic science was timely and relevant. Our dedication to providing the comprehensive education in these fields has positioned us at the forefront of addressing the evolving needs of the legal investigation communities. We are proud to announce our postgraduate program in criminal law and forensic science. Demand is too high in this field. The establishment of Forensic Institute and Raksha Viswadhyalaya in Lucknow underscores the government commitment to the reform, the administration of justice, and the realm of criminal law and forensic science. We are confident that under the guidance of Dr. J.K. Goswami sir, Lucknow will soon become a hub of forensic science in North India. Goswami sir, vast academic and procedural knowledge in the forensic science is invaluable, and we are fortunate to have his expertise. Sir, should you require any support in the achieving this esteemed objective, the Faculty of Law consider it is a privilege to offer assistance through collaboration or any other role that may be deemed necessary. As we are draw the curtain of 30 days interdisciplinary journey, I want to express our gratitude to the participants who join us from various corners of the nation. Your belief in us and your active participation has given us motivation to continue organizing such knowledge sharing event for the benefit of all. Bringing together a consultation of the experts from diverse fields of share their knowledge and vision with us was no small feat. I want to extend my heartfelt congratulations to the department and director HRDC Sayyid Aqil Ahmed, Tavi Saroj and Associate in Delhi, and the convener of this FDP for their exceptional efforts in making this gathering possible. I must also recognize the entire organizing committee for their unwavering dedication, hard work, patience, teamwork, and preservation in making this event a resounding success. Your commitment to the betterment and advancement of the faculty member from across the country is commendable. Again, I extend my heartfelt thanks to our valuable guests and wish to convey my best wishes to everyone present here. May the knowledge and experience gained during this FDP continue to enrich your professional lives, and may we all continue to strive for excellence in the field of criminal law and forensic science. Thank you so much.
Thank you, sir. Dr. G.K. Goswami, the chief guest in the Interdisciplinary Faculty Development Program's valedictory session. Sir, having an immense and a wide variety of um, academic accolades, he has concluded the Fulbright Nehru Academic and Professional Fellowship in November 2022 as Flex awardee, hosted by Professor Jens David Olin, the Dean of the Cornell Law School, New York, on the global legal challenge, wrongful convictions, and innocence claims. His entire academic endeavor has traveled length and wides of the United States and interacted with hundreds of domain experts, including the stalwarts like Professor Barry Shakes and Professor Justin Brooks. Earlier, he has served as the chief of anti-terrorist squad of the state of Uttar Pradesh in the rank of Additional Director General of Police. He returned to UP in 2020 after serving more than 7 years on deputation to the Government of India in various capacities, such as Joint Director, Anti-Corruption Headquarters Zone, Lucknow Zone of Central Bureau of Investigation, India. During this tenure, he was also posted as the director of the CBI Academy, Ghaziabad. On foreign deputation, he has served as an expert on organized crimes in the United Nations Office on Drug and Crime, UNODC, and had an opportunity to visit across globe to share experience and views on wide spectrum of issues related to policing and the law enforcement. Honorable President of India has honored him second bar by decorating 3 times with Police Medal for Gallantry, the highest national award for police. He is also the proud recipient of the Police Medal for Meritorious Service conferred by the Honorable President of India. His Excellency,
Dr.
the
Seema,
Governor of Uttar Pradesh, has also conferred upon him Gold Medal for Gallantry. Sir,
Madam,
being
if you can hear me, I think let us start. It is already you have told
sure,
a
sir.
lot.
I
So
formally welcome you to address the valedictory session as the chief guest. I am really apologetic for taking your that much time, but I am duly honored by your gracious presence in this valedictory session of our interdisciplinary faculty development program. Sir, the stage is yours. Thank you.
thank you very much, Dr. Seema and the entire team. And it is privilege always to interact the university faculties, the students, and many more. Of course, this is a very challenging field, as you all know. And on the onset itself, I want to tell you that the government of India is actually adjusting our criminal laws right from our penal code, procedure code, as well as evidence act. You all are aware. And at present, we have section 45 to 51 of Indian Evidence Act. Probably you all are aware, where experts had been dealt. But unfortunately, I must say that police as investigating agency has been given the optional, you know, to either opt for conducting forensic investigation or not, meaning thereby that in selected cases only police use forensic evidence for various reasons. I am not blaming anybody, but this is a fact. The reason may be the police may not be well aware about how to do it many times. Professional deficiency may do occur. And secondly, the resources may be limited. So these are various factors which are responsible, but ultimate outcome or result is that forensic science has not been utilized in our country the way it should have been. So this is a challenge, and now our Bharatiya Nagrik Suraksha Sanhita, the bill which has been introduced replacing our procedural code CRPC, its section 176 subsection 3 clearly indicate that once this act become law, this bill become law after getting through the parliament assent and all, right? Then crime or offense which award punishment 7 years or more. That means the so-called heinous offense, right? In all those cases, forensic investigation will be mandatory. The word shall has been used. So I request you to have just a look on that whenever you get time. The advantage of this would be that once this law get in place, then forensic aid to investigation will be compulsory. Although it will put a lot of challenge, and that is why the government has given 5 year time for the states to build the desired capacity, means the laboratories as well as the manpower. So the future of forensic experts, especially those who are the budding forensic experts, they are the students at this moment. I must say that they have a very bright future because a lot of institute will come up with time. Secondly, not only for the young students, even the judges, the prosecutors, the defense lawyers, all stakeholders which comes from the legal background, they have to update their knowledge in forensic science. I will tell you how this is important and how our new institute which you are referring, the Uttar Pradesh State Institute of Forensic Science, and of course we are introducing next year onwards the legal studies also. So ultimately it is a combination of forensic science with legal studies. So it is a different, ball game altogether. We'll discuss in the brief at the last, but let me just start. Uh, and I know that time is very precious for you as well as for me. So few slides I will skip because of time, but I will try to do justice because already we have spent nearly 25 minutes in just introduction and all. So we very limited time, but I will try to do justice with the subject. Okay. So let me just begin, and I hope You are able to see this slides, is it?
Yes, sir. Yes, sir. We are able to see that.
Okay. Can you just enhance the size? Okay. Huh. Is it visible to you?
No, sir. The slide sharing screen has been removed, sir. So
Okay,
kindly
just a minute.
start with the present. So the presentation has to be shared on the very present tab.
व्हाट्सएप पे क्यों चले गए इसमें? जब आपने इसे डाउनलोड नहीं कर रखा है इसमें स्क्रीन पे तो उस पर चले जाओ. Why are you wasting time?
Due to a certain technical glitch, the chief guest has been unstreamed from the session, and we are waiting for him to reconnect.
शेयर करो ना उसको.
So actually, the presentation. Yes, sir.
आपको
Yes, sir.
आपको मैंने भेजा है. Can you just see it and can upload it?
Sir, I have again streamed it. Now the presentation might be visible to you.
Sorry.
Sir,
So I have again
now we
streamed the
can see.
presentation.
No, but
The
this is
presentation
very
is
small
visible.
in size. It is very, very small in size. Although I can, but can you see it? Is it visible properly at your side?
Sir, we can see, sir.
So
No
the
problem, sir. We can.
slideshow of the presentation can be initiated, whereas it is visible. You can start with the presentation, sir.
Oh, चला ना आगे बढ़ाना. Move it ahead.
So if you start with the slideshow of the presentation, then it becomes all the more visible, sir.
Just एक मिनट. Just hold करो. Is it visible now?
Yes, sir, it is.
Okay. So I think you all are aware about what is law, and it can be defined through any act or any omission. If it is just and reasonable and fair, then it will be which was brought in by Maneka Gandhi case. So I don't take much time on this. But here I want to bring to your knowledge that triology for ensuring justice. Basically, in the judicial process, we have justice at the top, and I believe that if one attribute of society is being looked for, then probably it is justice. Because justice is the ultimate virtue of the society, of the individual. And the person who is not sensitive toward justice cannot be called truly a human being. Second point I want to say about justice is that justice is basically root cause of dispute in the society. How? For any kind of dispute, whether it is in the family, it may be of higher magnitude, maybe smaller magnitude, it may be a dispute between two neighbors, maybe any country or outside country or between countries. So the perception of injustice to be carried for the petitioner, for the complainant, is the root cause. Meaning thereby that when a person feels that some injustice has been done, then only a person goes to court or he says that I want to contest. So justice is the core. And how to reach to justice? Basically, it is truth. Truth behind a fact. So truth is the route by which you can deliver justice, right? But if you look at justice and truth, both are intangible attributes. You cannot quantify directly. So what is the third important, segment of this triangle is the evidence. My dear professors, evidence is a tangible unit by which you can reach to truth. And then, of course, it will help you to deliver justice. So the probity and quality, the righteousness of evidence is the fulcrum. That is very, very important. Why it is important? Because if evidence is challenged, and normally in our trial system, most of the time we rely upon oral testimony. And you are well aware that oral testimony have so many challenges. Person may have personal vendetta, may have some duress, may have some faded memory. So many challenges must be there. So merely having oral testimony, including eyewitness, may have reason to believe that there may be miscarriage of justice. There are chances. So how to bring fairness in justice delivery? You need to have some kind of neutral and scientifically approved corroboration. So my dear friend, basically for improving the quality of evidence or improving the quality of justice, you need to have some technique, some methods of corroboration. And forensic science is a tool. And I must have this disclosure right from the beginning that, as you know well, you have legal background. So any evidence other than ocular witness are called secondary evidence. So likewise, forensic evidence are secondary in nature, but they are very, very important and pertinent to establish truth. Secondly, the advantage of this technique or these evidence are they are neutral. They can be utilized both for establishing guilt as inculpatory evidence. Simultaneously, it can also help to establish innocence, that is exculpatory evidence. And you will surprise, I will tell you in the end that DNA, when it was introduced in the courtroom, basically the first contribution was to establish the innocence of Richard Buckland. I will tell you the story of that, how DNA spectacularly entered into the criminal courtroom in 1986. That is a good story to understand. Okay. So with this background, Now, we are aware that justice, truth, and evidence, it is a very important trilogy. But let me just move a little ahead. And now you all are aware that basically investigation is nothing but it is a voyage, or it is a travel, it is a journey for discovery of truth. And here I tell you another important point is fair trial. Dear friends, we have a lot of discussions even in all kind of covenants, right from UDHR of 1948 and in 1966 various covenants, then regional treaties and whatnot. Fair trial. But can you really say with certainty that if somebody has muddled with the quality of evidence during investigation, meaning thereby if evidence is challenged, it is not fair, then can any court, whatsoever the authority it may be, even the International Court of Justice, can they do justice? Can a trial be fair? So I think until unless we ensure fairness in investigation, righteousness in collection of evidence, merely thinking of fair trial is a completely false preposition. Unfortunately, what we did, we have given undue, I don't say undue, but lot of importance thinking that judge means justice and justice means judge. No, it is not. Judge had very important and vital role, but he is not the ultimate, repository of justice. He has its own role to play. Before a case reach to court, lot many things, a huge water flow in the river. Till we ensure fair investigation, no trial court, no apex court can do justice without any iota of doubt. There will be challenge. There will be possibility of miscarriage of justice. So, in my opinion, fair investigation is precursor to fair trial. Okay. So all these things are important, but let me just move because time is rushing and I have to do little more discussion. So another point one should understand clearly here, that what is the objective of investigation in general, whatever it may be, body offense, it may be a property offense, it may be a family offense, whatsoever it is. So many issues and challenges, right? So the ultimate objective of investigation in entire spectrum is to correctly identify a human being. It may be, the human may be a victim. Sometimes you may get a child who may not be able to disclose his identity. You have to establish identity, right? Sometimes you may have a person who may be challenged. He or she may not be able to speak or to write. Maybe an insane person. Sometimes you get a body, that body, which the morphological features may be there, face may be visible, but you don't know who is he or she. Likewise, you may get some body remains, the bones. So, victim side, the challenge remains the correct human identification. Of course, on the other side of the story, the accused side or the suspect side, it is more grave. The entire proceeding of investigation is to correctly identify that who has committed this crime. Connecting crime with criminal without any iota of doubt is basically objective. And these are various features. How the scientific aid can help for human identification, either side. And of course, you are well aware that DNA is the ultimate technology currently available for fair investigation and scientific aid to investigation, right? Next. Now, before I move, I'll just tell you that just have a look on rape incidents, just to give what is the importance of forensic science, what we are discussing today. Just this slide will give you a kind of glimpse. Here in nearly 90% cases, if you see the chart sheet, the red bracket in the left side, in nearly 90% cases of rape in India since 2014 to 2021, In 90% cases, completion of investigation, police complete the investigation, think that we have done our job, and they file charge sheet, right? But once it reaches to the trial court, they evaluate the evidence collected, but they found that, look, your evidence are not sufficient enough to convict the accused, and thereby the rate of conviction is nearly 30%. So this gap of 60% is a challenge, and we have to find the answer today, actually how to bridge this gap. It means there are two possibilities in charge sheet cases. Either the person was wrongly charge sheeted and got acquitted, but he was charge sheeted wrongly. Secondly, there are possibility that person was actually involved in the crime, but somehow because of insufficient evidence, he got advantage and got acquitted, right? So this is a very, very big challenge, and we will try to find solution to this problem. Likewise, if you see the POCSO cases, the child sexual abuse, again the scenario remains same. Charge sheet in 90-95% cases, and conviction rate is only 30 to 35%. So again, 60% gap. And my dear friends, it is not only the rape incidents, even property offense, like human trafficking. Even human trafficking, this gap is very, very vast. It is nearly 80% gap. Only 20% cases hardly get convicted. Hardly. So how to bridge this gap? We will try to find out the answer. I hope we have got the clear-cut, objective of today's discussion, that what are our, questions to address. We know all that how we actually put forth our witness from the prosecution. So to prove a fact or to disprove it, right? How many witnesses are required? Section 134 of the Indian Evidence Act answer it. It says it may be one, it may be many. So it depends actually the party involved who want to prove or disprove a fact, that how many individuals as witness they want to put forth. It may be one or more. And I already said that eyewitness or any oral witness have inherent challenge, like they may be planted, they may have personal vendetta, they may have memory loss after some time, and there are so many other constraints by which there are ample scope for miscarriage of justice if we totally depend on oral testimony. So as I already mentioned, we need to have a solid ground, and better to have some scientific aid for corroboration. So when we utilize forensic science in criminal side, then it is called criminalistics. What is that? It is basically a scientific temper. It infused scientific temper in investigation. It is a scientific aid. It is neutral, right? The purpose is ultimately to enhance probity so that the quality, the righteousness get improved of the evidence, what we produce before court, so that we can move towards perfect justice. So bringing perfectness in justice is the object of the entire procedure. And I generally say one statement, even I used to go for as a professional, as an expert, even to the National Judicial Academy, Bhopal, where higher ranks judicial officers comes not only from the country, but across globe. There, in one of my lecture, I stated one sentence, and I repeat here. Just patiently listen it, and just you may have some reaction also. It was something like this, that see, a judge, whatsoever rank and profile may be, he delivers judgment. A judge delivers judgment. It is your good luck, or it is the good luck of the parties involved, that if they get justice. Normally, if somebody says this type of statement before officers, senior rank officers sitting as judges, as audience, then there are possibilities that they may get annoyed. Okay, but they were quite supportive. Why I said this, and what is the qualifying sentence, whether this is right or wrong? The purpose is basically that if it is the guarantee, the judgment is sine qua non or synonym to justice, then what was the need of having justice, having appeal? The doctrine of appeal, having doctrine of appeal in place means that there is possibility of miscarriage of justice, even in any kind of judgment. That is why we used to go for higher bench, even in Supreme Court. Right? Just a minute. I just want to have some urgent thing to attend. Just a minute, please. Okay.
बोले कि सर की परमिशन के लेटर पे भेज दीजिए, नोटशीट पे ना भेजिए सर।
लेटर पे भेज दो। Okay. So am I audible? I hope.
Yes, sir. Yes, sir, you are audible.
So now let me just explain who is an expert. That's a very, very important part. So our section 45, if we see what are the existing legal framework in India. So I just want to explain in 2-3 sentences only. We have footprint of expert opinion in our Indian Evidence Act. And you will be surprised that there is no word called forensic science in that. We call it for expert. And expert is not defined, it has been expressed. The definition is a challenge, I will discuss with that. Section 45 per se of the Indian Evidence Act says when the court has to form an opinion upon a point of foreign law. Even see, science is after foreign law. So it is not only science, we get confused. So any person having expertise in foreign law, science, even art, maybe archaeology, maybe painting, maybe some other areas, right? So even art, subject of different arts, or identity of handwriting or finger impression. So meaning thereby that we should not get confused that expert can only be a scientific trained person. He may be expert in any area, maybe in linguistic field also, anthropology, archaeology, so many areas, right? So the qualifying sentence, there is no definition of this expert till date. It says, or it qualifies that the opinion upon the point of person is specially skilled. I have made it red deliberately just to bring your attention. Is specially skilled. Who is specially skilled? Nowhere defined. Again, so this is a conundrum. Who is an expert still remain a challenge. I will tell you the next thing. As I already mentioned, that's section 176.3, mandating compulsory forensic investigation. No discretion will be left once this law will be in place. Now, as I said, who is an expert? Now see this case, so interesting. Despite having, if I go back, especially skilled, but you just see the interpretation in 1974 in this case, Chandra Batra of our state only. Here, the case was something like that. The excise inspector has given a report that it is a spurious liquor. And he gave this report based on smelling power, his own smelling power. So now the question arises whether the excise inspector may be considered as expert or not. And it was decided by Honorable High Court in 1974 that yes, it can be considered as. Now, can you just think, is it possible for anybody, whatsoever experience he may be having, that just by way of, smelling, he can say whether it is spurious or not? This interpretation, in my opinion, was not tenable, was not correct. But it shows that lack of F is that the lack of proper definition of expert. And this conundrum, this deficiency do exist till date. There are various judgments where you will find that expert has been defined or interpreted in a very, you can say, unscientific manner. Now, this answer came very lucidly in another judgment of the Apex Court of India in Jalal case in 1999, where it was discussed that what is specially skilled. Specially skilled can be determined by evaluating his education, whether he is educated or not. This was missing in earlier case of excise inspector. There it was not expected whether he is educated in that field or not. It was only experience. Here, especially skilled has two components. One is his education, formal education, and second is experience. So in the earlier case in Chandra, it was only experience which was considered, but the missing part was education, right? So when you define or when you determine whether a person is expert or not, this is one criteria, but there are no foolproof criteria so far. This is a big challenge, and you must be aware that expert is not a witness of fact, right? He is a witness of law, right? Some other judgments are also mentioned, right? If we see laws in US and UK on the same point, it entails in US under Rule 7002 that the expert must be qualified. That means the education part. The testimony addresses subject matter on which the fact finder can be assisted by an expert. The testimony must be reliable and the testimony fit the fact of the case. So these are certain points which we can just ponder upon for discussing our own definition, because now we are actually making our law again. So I think this is the right time. The expert should be well defined without leaving any scope for any iota of doubt anymore. So that is the expectation of an expert, of an academician, so that these things should be taken care of. These are some ethical things. I just skip. Wrongful convictions also I want to skip, because I will just come for DNA. Okay. So DNA, actually, let me just give you a kind of story behind how DNA forensics, or you can say DNA fingerprinting, the first name was given by Watson and Crick, and this was the helical structure, double helical structure it is called, and it was given in 1953 by Watson and Crick. Both were awarded Nobel Prize at that time, and this discovery was a revolutionary which became the baseline for biotechnology. And all we know that these days biotechnology is part and parcel of almost our life. Everything has some footprint or other of biotechnology, right? So DNA becomes a molecule which is most vital, whether it is in criminal side, whether it is in life science, whether it is in medicine, agriculture, even the aeronautics and whatnot. So many areas actually DNA has its footprint in different manner for the purpose of improving the quality of life and research and development. So this is the gentleman who actually is the father of DNA fingerprinting, Dr. Alex Jeffrey, right? Incidentally, I had interaction with him many times for my research work and others, but he's a very thorough gentleman. Now he's a retired professor and enjoying happy life in London. So in 1970s, late 1970s, this gentleman was around 35 of age, and he was a postdoc fellow, postdoctoral research he was conducting, and he was actually a geneticist and has no business to work or to research anything which is related to justice system. He was purely a geneticist and was looking for the research question for him was whether through genetics, right, whether the parents can be linked with the children. That means, can genetics be helpful for establishing pedigree analysis? Right? That was the research question. And for that, he actually was PDF postdoctoral fellow in Lancaster University of London, and he collected the biological material blood sample of his lab assistant and 2 of his kids. And they were trying, or his team was trying, to establish genetic linkages between parents and progeny, children. And on 9th September, in the morning around 9:05, he said Eureka moment, when he established that yes, parents can be connected with the children. If you know, many of you may be aware about chromatography. Nowadays, the DNA technology has become almost automated. But earlier, when it was beginning, and not only beginning, I think at least 2 decades or maybe more, the chromatography and very, mundane type of techniques were being used to compare the, chromatographic gel and other things, the bands and all, right? But nowadays, it is completely computation and permutations, combinations are there, right? So this was the first landmark actually, and this is called the first milestone. And this research got widely publicized because it was connecting human beings actually for the purpose of human identification, for the pedigree purpose. He gave to the term DNA fingerprint, DNA for the genetic material and fingerprint for the purpose of human identification, because fingerprint is considered the tool for human identification. So this terminology was coined by him, DNA fingerprint. So this was first, it was published widely, the paper came in Nature and all, right? Widely, world was overwhelmed with this research, okay? At that point of time, in 1985, the second very important incident happened, which is worth mentioning here. One lady, Ghanaian lady, was basically living in London with 2 of her children. And she wanted to immigrate one of another child of younger age, around 2.5 years or 3 years. Somehow he was left in Ghana when she actually got immigration clearance in London. As usual, the immigration authority, having doubt, denied the entry, thinking that the child does not belong genetically to the mother. This dispute was continuing. There was no resolution of this dispute. Meanwhile, the advocate of the Ghanaian lady requested the authorities, saying that, look, in the same city, London, where we are living, and this case is actually for dispute resolution, Alex Jeffrey has invented a technique that is scientific technique, widely accepted everywhere. People are praising him. And the question is same. Here also we want to connect the mother with the child, and that DNA fingerprinting technology is actually meant for this purpose. So authorities accepted this proposal. Alex Jeffrey took the blood sample, and when this test was conducted, when the report was placed before the immigration authorities, it disclosed that child actually belonged genetically to the mother. And Alex said at that point of time, when authorities permitted the child to enter in the city or to cross the border, the gratitude in the eyes of mother, when she looked towards Alex Jeffrey, he said that it was the best award for my research. Here I want to convey that when you actually deliver justice to anybody, the gratitude, the satisfaction, the person at the receiving end feels, it is incalculable. This is the actual service to the humanity if we are part and parcel, or if we contribute somehow or other to deliver the justice in the society. This is the prime job. We should always strive for getting best tool for ensuring justice without any iota of doubt. So this was the second landmark. The third was in 1986, and this is a very, very important part where spectacularly the DNA entered into courtroom, in the criminal courtroom rather. The story goes like this. Then in 1983, near London, in a suburb area, one girl around 14 to 15 years, she was brutally raped and then killed, and body was found lying there. It was a blind case. It was not disclosed. It was never uncovered till 1986. In the similar manner, with the same modus operandi by and large, almost at the stone thrown distance from the earlier incident in 1983, the second incident happened where the same age girl was raped and brutally killed in 1986 at the almost same place. Again, it was undisclosed, having no clue. So both these cases were undetected. Incidentally, the investigator, the detective, was the same person named David Becker. He was a policeman of very high, you can say, caliber. He actually, in 1986, he caught a suspect named Richard Buckland, and incidentally, this is a very strange to say that he accepted or he confessed to commit the second incident of rape and murder in 1986. But he refused to accept the first incident. He was placed before court. Court asked certain questions, and after due diligence, the court thought that he probably is not the right culprit who had actually committed this crime, even the second one. So despite the fact that the cloud of doubts were still hanging around Richard Buckland, but he was released with the direction to the investigating agency that you collect more evidence against him if he at all is an offender. Right. So at this time, when David could not get any clue, he thought that Alec is actually helpful in identification of human being. Why can't we use this technology for identification of this criminal or these criminals if there are more than one? He went and approached Alec Jeffrey, and disclosed the fact of both the cases. Alec was very, happy with this proposal. He accepted this challenge, but this technique was very expensive. When they, explore the potential rapists in that area, they were more than 5,500 in numbers. Now you can well imagine the cost involved therein. I hope I am visible and audible.
Yes.
Hello? Can anybody
Sir.
respond?
Yes, sir.
Fine.
Yes, sir. You are visible and audible both.
On the screen, so I thought that I maybe lost the connection.
No, sir. You are there.
Okay, thank you very much. So this was a big challenge. It needs a huge amount of money. So this matter went up to the UK Parliament. The then Prime Minister, Mrs. Margaret Thatcher, she actually was instrumental to allocate the fund by special permission of the, the fund was especially, allocated for this purpose by the Parliament of United Kingdom. The matter starts. First, they took the blood sample of Richard Buckland, and the analysis of DNA proved that he was innocent. So DNA, when first result came in the criminal side, it was to prove innocence of a person. Earlier it was a doubt. Now the DNA get clearance that he is not involved either of the two. right? Both the incident, he has no business or no connection with the crime and criminal. Okay, so meaning thereby DNA establishes its credence and its potential to prove innocence. And my dear friends, proving innocence remains a big challenge. We always talk about conviction, conviction, and conviction, right? I think as student of law, we must understand that we should be neither for conviction nor for acquittal. We should be for justice. We should not implicate anybody wrongly. And this is a big challenge for any society. And the law very clearly says, right? Blackstone has mentioned it long back that let hundreds of culprit got scot-free, but not even a single, innocent be punished. But what happened in society? Do we really look for this dictum, which was given about 3 centuries earlier? Still, we do not bother. We generally, only consider the rate of conviction and what not. But in my opinion, despite I am a police officer, I do agree that there are, ample possibility that an innocent person can be convicted and may put behind the bar, right? So this was the first contribution of DNA to prove innocence. Then nearly 5,000 people were screened, but there was no result positive. Means despite conducting more than 5,000 samples, there was no clue. That means there was no detection of the real culprit. It was a matter of very frustration to the team. At this point of time, very important incident happened, which is a very classical to mention. That in the evening, on a pub, Jan Kelly was sitting. Jan Kelly was a middle-aged man at that point of time. He was discussing with his friend sitting beside him that, look, one of Jan Kelly's friend named Colin Fitchfork, he has requested Jan Kelly to impersonify in his name and to give blood sample to the test. For the purpose of test, that please you go and just tell that I am Colin Pitchfork and in my name please give the blood sample. And believe that he successfully did it. Meaning thereby that Jan Kelly has given his own sample in the name of Pitchfork. This, whisper or this hearing, what they were discussing was overheard by the service provider or the servant who was serving at the pub. It was transpired or it was transmitted. The information was shared with the police. Police caught Jan Kelly. He disclosed that his friend was Colin Pitchfork. His sample was taken for the test and rest is the story. Meaning that Colin Pitchfork blood sample matched with the samples collected from the deceased of rape and murder, right? So both cases he was the culprit. And just one point which is worth mentioning, that he was living very close to the incident where both incidents were happened, very close. And he was having a big criminal record, more than 50 type of, different type of, incident. He was already being reported in the near police station. But you see, sometimes not only in India, but this type of overlooking or casual approach is being exhibited not only in India but many other countries. Just a minute, I will come in 2 minutes, please.
Due to the various academic engagements, our respected chief guest has taken a break. So we are just waiting him to resume the session.
So this is the story, and afterwards, this was very well accepted in the criminal court, and lot many. Although the acceptance of DNA in the criminal court was not that easy as it looks on date, lot of stories were there, but it has served a lot across the globe, and India is also widely using it. I think now, because time has already, so there are so many challenges. I don't want to take. Yes, this is one point I want to just tell that this is our institute. Basically, I want to just have 2 minutes time and your attention. Basically, this institute named Uttar Pradesh State Institute of Forensic Science, UPSIFS. It is located near Amosi Airport, precisely in the area of police station Sarojini Nagar, and the name of the village, it is very close to Kanpur Lucknow highway, and it is very close to Daroga Kheda village. Okay, and it is a huge campus, more than 50 acre. Of course, Integral University seems to be very large, but because your university has various departments and all, but we have a very limited domain. But we want to explore the heights in the field of forensic science and law. So, what is the specific points which is nowhere found in the universe, in the globe? What are the special features which we have introduced here, or we are in the process to introduce, I can say? So, crime scene management, basically how crime scenes should be protected, and a lot of challenges comes if the crime scene is being challenged. There may be some kind of alteration, manipulation, and some mischief may be there. So how to manage it? We are in collaboration with Indian Institute of Management, Lucknow, and many more such institutions. And we have planned actually to go beyond any institution which we can think to build better system. So IIM, we are planning to have a better quality of crime scene management than the laboratory work, accreditation, and normally the problem remains that the samples which goes from the field, from the police station to laboratory, they are not being codified. So codification and decodification, and this area is very critical. Why this manipulation? Generally, you have heard many times that various reports are being altered, being defaced. If you know that whose sample is it, what is the crime number, which place it belongs to, then there are likelihoods. So that can be done. It is not a very Herculean task. Nothing to reinvent the wheel. There are protocols and everything. So this is second part. The most important, and which is the unique for this institute, is basically how to convert expert opinion into credible evidence. Let me just explain what it is. Basically, expert provide you expert opinion. It is not an evidence at that stage. He says that whether the sample belongs to A or B or not, whatever is the question. So they does not know that their expert opinion, whatever is their finding, whether it helps the prosecution to prove guilt or it helps the accused side or the suspect side to prove their innocence. So it is completely neutral. Right? Unlike any witness. When we produce witness from the prosecution side, he talks the prosecution story. When we produce the witness from defense side, he talks the defense story. Right? So here the corroboration is neutral. It is scientifically aided. So this is actually how you convert the expert opinion into credible evidence. Unfortunately, what happens, as I normally say, that if you see in the courtroom, there are 4 type of people generally interacted with forensic science. One is the judge, the honorable judge, the learned judge, then the prosecutors, then the defense lawyer. Judge, prosecutor, and defense lawyer, all three have the background of law, legal experts. They do not have sufficient knowledge of forensic science. So they are very right, and there are so many judgments which clearly indicates that forget about the lower judiciary, the prosecutor, even sometime the misinterpretation of the legal the scientific precepts are existing in the higher judiciary, not only in our country, but it is across problem. So it is not that this requires attention of India only. It is a pan-globe issue, right? On the other side, there is one fellow for testimony or for cross-examination is the expert standing for the witness, as a witness. Now he talks science and they understand law. The meaning thereby, the expert is the man of science and judge, prosecutor and defense lawyer, they are the men of law. They do not understand their language. And now this merger is important actually, until unless they are on the same page. That meaning thereby, and I request here also, that if you are teaching law, the proper segment of forensic science, I am not saying that lawyers should be forensic expert. They are not expected to go and test and all, but they should know the basics, what the forensic science is. Where are the strengths? Where are the weakness? What is the metadata? How to understand that? How you reach to this conclusion? So if you see, they ask very silly questions because they do not understand, right? Likewise, the forensic expert, he only knows science. He does not know anything ABC of law. So our institute is actually has identified this gap, and we will be providing the education to forensic expert to some extent the legal understanding. Likewise, for the legal expert, when we are introducing BSc Forensic Science and LLB, the 5-year integrity course, generally people has BL. Some segment of legal knowledge. Properly, they should understand that how the evidence are being placed in our procedural instruments of law and how it get interpreted. So this is the uniqueness what we are actually pondering and we are envisaging. And with this, I think now I have taken, although I understand that many things could have been told. And another point, if those who have some understanding or want to read more about, because I have told you the brighter side of forensic science. There are the very, very dark side of forensic science also, right? Like I tell you that we talk about bite marks. Bite marks is not a science, not at all. It's a completely bogus science. It has been proved, right? Likewise, comparison of hair, completely bogus. It has no scientific, validation. Likewise, we believe that, and since our birth, almost birth, you can say, or when we got little awareness of the society, we were being taught, we were being told that fingerprint is unique for everybody. But can you believe this? There is no empirical data to prove this. I am not saying that you discard them, that they cannot be the sole criteria for conviction or taking the final decision. You can only screen out if there are, say, 50 people. If their fingerprint, suppose 2 persons, they get matched, then you have more doubt on them. Collect more evidence. You can reach to the more, you become close to the core of the issue. Likewise, polygraph. Polygraph is not a valid science. I would have told you why that is not a valid science, or per se it is not an evidence. It is only the ray of hope in the dark cases. Say, for example, there are 50 odd number of suspects. So if you conduct polygraph test and you get some doubt on 3, 4, 5, then you may focus on them to collect more and more cogent evidence. But merely on the report of polygraph or narcoanalysis or brain mapping, if they say that this is false, this is no, this is completely there. There is no machine which can just people think about lie detector that you put in, node and person start telling the truth. No, this is not the fact. So we should not misunderstood the challenges of science. There are so many challenges. So with this, I conclude and I leave up to you. If there is any question, I will be happy to take. But thank you very much for patience listening. Although I am the it is only monologue. So I don't know how much I could convey the message because it is like almost rushing. I understand that such a vast subject and topic, but in nearly
No, sir.
not be
Thank you, sir, for your immense knowledge and varied experience in the field of forensic science. Obviously, it has been a very well-suited finale for the event because there have been many of the revelations which have not been up till now. It has not been disclosed in any of the sessions, and to our very delightment, the participants in the because we are relaying this as of the very live telecast of this particular session is being done on our Faculty of Law Integral University YouTube channel. So for our very amazement, there are participants who have posted questions as well on your very delightful, informative presentation. There is a particular question. I would like to invite our Professor Javed Musarrat, VC sir, respected VC sir, has also joined us in this valedictory session, and he has been there from the very start. I'm really, sir, we are delighted to have you here in the session, and thank you for joining us and giving us that much of time. Sir, with due respect and with due permission, obviously with the authorities, I would like to pose this question as one of the participants has posted on our chat box. Sir, kindly, if you would take the question, Goswami sir, if you want to take the question. Yes, sir. So, how forensic science plays a major role in the case of someone missing and how they collect the data. And he has specifically mentioned the case of Najib Ahmed, a Delhi biotech student, and he is particularly in the awe of gathering information with that particular case. How forensic science has played a major role in the case of someone missing and how they are collecting the data.
You see, it is a very, very pertinent question, and DNA and many other techniques can play a very dominant role, right? But unfortunately, in our country, we do not have the DNA data bank, right? So this is a big challenge. Like in US, if you see their CODIS, right? And many other countries, they have the data bank. And because we do not have the data bank, that is how we cannot find the right person who have actually committed offense in that cases. Secondly, the person, even if you find sometimes the dead bodies, then you may not get the correct, until unless you know that who the person, maybe suspected person, the body has been found. Then you go back to the parents or to the family members, collect the data and all. Suppose if we have data bank of the entire population, like our Aadhaar card and so, and then if you get any dead body or anything, then by simply conducting DNA, you can easily connect that who the person with the deceased dead body, right? So that is the missing part. But another very important point which he or she, whoever asked this question, is the missing children. And I propose many a times, I don't know, it is not that easy to do, but I think government may take up sometime this type of project. Say we have a lot of children missing, okay, and they are lodged in either in a government, protection home, or they are being somewhere or other, roaming on road, or they may be on various, in very different shape. They may be in flash trade, in prostitution, sometimes they may be begging, then so many other things, right? So if we have the data from the parent side where the child was missing, there must be a missing report. So if we collect DNA sample of each missing child parent, right, and if we just start collecting data from the protection home where the children have been lost, or from railway station or something where the orphan children are being there, I tell you, just by clicking, by this way, we can connect children who are missing since long in almost in a second time, just by just clicking. Immediately you will get the who is the parent, right? But I think,
Right.
as I mentioned, that we have to build a robust DNA data bank. There are challenges in data bank because there are so many privacy issues and all. But for the purpose of human identification, we do not have to have the entire profile for DNA, right? So it can be
Right, sir.
minimized. The exploitation part of the privacy right can be protected, but we have to have such type. I think the efforts have been made by our parliament to build the data. Let us see, it should be done at the earliest possible. As he mentioned about a case, see, until unless we get the dead body, right, then it's very difficult for any technique saying that whether a person is, where is the person. The techniques which we are talking, those techniques can connect when we get a body or a person. But other techniques are also there. Say, for example, digital footprints. Suppose a person is missing, he carries any mobile phone. If you have some doubt on somebody, then his mobile phone or his connection. So many digital footprints also helps to identify. So it is not only one technique which help you to reach to the logical conclusion of a case. It may be a bundle of techniques sometimes. It may be helpful of the oral testimony also. Somebody may give you some kind of clue and then you go for. So it is a hybrid of various efforts actually. It may be different technology of forensic science, then maybe different type of people whose testimony or whose statement may also be helpful. So reaching or to disclose such type of complex cases is a very, very challenging, but it is a complex task.
Thank you, sir. Indeed, it's suitable. It would be suitable if I use that this has been a technical valedictory session and the finale to this FDP. And here we are privileged to introduce a luminary amongst us in the realm of academia, Professor Javed Musarrat, sir, our esteemed Vice Chancellor at Integral University, Lucknow. His presence amongst us signifies an embodiment of knowledge, experience, and a relentless pursuit of excellence in higher educational administration. Sir, we welcome you as a beacon of academic excellence to this particular faculty development program. And as a patron in chief, I would like to welcome you and address the valedictory session.
Thank you very much, Dr. Seema. I hope my voice is audible there.
Yes, sir.
Yeah.
Clearly.
Okay. Thank you very much. So, Dr. G.K. Goswami, Director, UP SIFS, Advocate Dr. Tabish, a very senior advocate, esteemed guests, participants, faculty members, students, ladies and gentlemen. I am so pleased to join you all at this valedictory session of this month-long interdisciplinary faculty development program organized by the Department of Law at our university. So today we celebrate the successful culmination of a truly enlightening faculty development program on the topic emerging trends in administration of criminal justice and forensic sciences. This program has provided the teachers and scholars of this university and other institutions with an opportunity to delve into the subject where science intersects with the law, exploring the pivotal role of forensic science in matters of criminal and civil justice. Now, before I proceed further, I would like to take a moment to express my deepest gratitude to those who have made this program possible. And in this context, I extend my greetings to the head of the Department of Law, whose unwavering support and guidance have been instrumental in steering this program to success. I appreciate the dedicated effort of your team of teachers and the student, Dr. Seema, and the resource persons in the pursuit of knowledge and your commitment to the academic growth of our participants. I also acknowledge the tireless efforts of the Dean Faculty of Law, who has provided us the platform to explore the intricacies of emerging trends in administration of criminal justice and forensic sciences. A program of this magnitude would not have been possible without the meticulous planning and execution of the entire team of organizers. Professor Naseem, your hard work and unwavering commitment to the success of this program have
Thank
not gone unnoticed,
thank you,
and
sir.
I'm deeply appreciative of your efforts.
Thank you, sir.
Thanks to Dr. Goswami ji for a very insightful and a lucid presentation. My sincere gratitude to all the resource persons and esteemed experts who have taken time to deliver insightful lectures on various aspects of this critical topic. Your knowledge and expertise have been cornerstone of our learning experience, and we are honored to have had the opportunity to gain wisdom from your shared insights. The topic of FDP, the emerging trends in administration of criminal justice and forensic science, is of paramount importance in today's where science and law intersects, and it has the power to bring forth physical evidence that can be the linchpin in ensuring a fair judgment. The rate of conviction on an average is 33% due to insufficient evidence. That's what Dr. Goswami ji has mentioned. And he has very rightly pointed out that to bring fairness to justice, the probity of evidence using technology plays an important role. And he has used the terminology criminalistics for scientific investigation, for probity leading to perfect justice. So, advancement in science and technology have paved the way for rapid development in forensic science, and the evidence collected at the crime scenes is crucial for a just verdict. The reports from various commissions underline the importance of courts adopting scientific methods in delivering judgments, as fairness is the hallmark of any democracy. India's rich history in forensic science, dating back to the establishment of the first official crime lab in 1878, has furthered this journey with 7 central forensic labs and more than 35 state forensic labs now in operation across the country. The Indian judiciary now increasingly relies on the advanced forensic methods, including fingerprinting analysis, DNA profiling, genetic polymorphism, RFLP analysis, and of course, mitochondrial DNA analysis. And this last part, the mitochondrial DNA analysis, is important because it's a genetic marker for tracing maternal genealogies. So these methods have become integral to the pursuit of justice, and they have also paved the way for technologies such as narco analysis and lie detectors, enhancing the field of forensic science. I'm happy that Dr. Goswami has talked about DNA, and Watson and Crick, who have proposed the structure of DNA as a double helix. It was fascinating hearing a police officer talking about DNA. It simply reflects his interest in discussing the advancements in molecular biology and the implementation of molecular tools in forensic sciences. Ladies and in physiology and medicine. It was way back in 2010 when I was the chair professor DNA research. However, as we have delved into this field, we have also encountered debates and concerns regarding the use of forensic evidence in the court of law. For instance, Article 23 of the Indian Constitution, which safeguards individuals against self-incrimination, has raised questions about the compulsion of accused individuals to provide fingerprints and DNA analysis. Now, some people argue that this contradicts the principles of self-incrimination. But the Supreme Court, in the case of the state of Bombay versus Katikalu, Agadh, and others, has upheld that compelling individuals to provide forensic evidence does not violate this provision. This is further reinforced in Section 73 of the Indian Evidence Act. Similarly, the admissibility of narco-analysis evidence has also sparked debate. Questions have been raised about the ethical and legal implications of acquiring statements from semi-conscious individuals in this matter. While the constitutional validity of narco-analysis and lie detectors was initially upheld in the case of Ramachandra Reddy and others versus the state of Maharashtra, the 2006 case of Selvi and others versus state of Karnataka and others held that statements obtained through brain mapping or narco-analysis could not be considered conclusive. Thereby, their conclusion in compulsory investigations. Further, the autonomy of forensic labs has emerged as a significant concern. Forensic science laboratories in India often falls under the jurisdiction of their home department or the police department. I trust these issues and many other important aspects would have been discussed in the technical sessions in the last 30 days. So at the end, I personally feel that we conclude this program, we may find ourselves at an intersection of science, law, and ethics, armed with a deeper understanding of the evolving landscape of forensic sciences and criminal justice administration. It is the collective responsibility as individuals who have undertaken this journey to carry forward the knowledge and insights that you have gained and contribute to the ongoing discourse on these crucial matters. So I once again extend my sincere appreciation to all those who have been part of this academic journey. I urge you all to work together towards developing a just and equitable society. Thank you very much, in fact, for giving me an opportunity to share my thoughts with you. Thank you very much.
Thank you, sir. So, this entire month-long journey of the interdisciplinary faculty development program, today I can conclude it, and with pride I can conclude that it has led even our respected vice chancellor, sir, to make a research on the legal points, and his unattainable desire of becoming a lawyer is coming to somewhere. It is coming in the very mainstream, where we can see that he is doing research over the various forensic science issues and the case laws as well. We were really impressed, sir, with the variety and the immense research which you have done for our theme, emerging trends in administration of criminal justice and forensic science.
Thank you very much.
So the decorum of the entire event, and as the tradition goes by, every event has a formal culmination with a formal vote of thanks. For the proceedings, I would like to invite Dr. Mirza Junaid Beg to deliver the formal vote of thanks.
Thank you, ma'am. In the name of God, the most beneficent and the most merciful. There is no greater threat to a free and democratic nation than a government that fails to protect its citizens' freedom and liberty as aggressively as it pursues justice. A very good afternoon to all of you present here in this virtual platform. A Thanksgiving is a time for feeling gratitude. The success of the event is dependent upon the blessing and accolades of the resource persons invited, the event management team, participants, and all wishers. In the capacity of the co-convener of the Interdisciplinary FDP, I thank you all. Our patron, Professor Javed Musarraf sir, respected Vice Chancellor, on behalf of the entire team, we offer a heartfelt thanks for your gracious virtual presence and time out of your busy schedule. Professor Sayyid Wasim Akhtar sir, Chancellor, Dr. Sayyid Naseem Akhtar sir, Pro-Chancellor, Professor Muhammad Haris Siddiqui sir, Registrar, Professor Sayyid Aqil Ahmed sir, Director HRDC, Dr. Mishabul Hassan sir, Director IQAC, and Dr. Naseem Ahmed sir, Dean Faculty of Law, Dr. Seema Siddiqui, Head of the Department. These both personalities are the brain and heart of this very faculty. And Dr. Abhishek Kumar Singh sir and Dr. Sadaf Ma'am Khan, the senior most faculty member of this department. And these two faculties are the backbone of this very department. And our special guest, Advocate Tabish Saroj sir, authorities of the Integral University. Your mere being presence is the source of achieving excellence in any task undertaken. Gratitude offered and thanks are in a competitive, the strength and inspiration flowing through your encouraging words. I would like to thank our chief guest, Dr. G.K. Goswami sir, ADJ, founder, director, UP State Institute of Forensic Sciences, Lucknow, who graced us with his thought-provoking and motivational wisdom. And the participants present here will have a lot to take away from this valedictory session. We all are inspired by your great words, sir. Thank you so much, sir. We have been fortunate enough to be backed by a team of very motivated and dedicated faculty members and students, including Ashraf sir, Manzoor sir, Nidhi ma'am, Uzma ma'am, and Huma ma'am. And our student coordinators, Qazi Muhammad Farhan and Mustafa Faruqi. I cannot thank everyone enough for the involvement they have shown and the willingness they have expressed to take on the completion of tasks beyond their comfort zones. Again, I would like to thank you all the dignified and esteemed resource persons who have graced us various sessions of the said SDP. Last but not the least, I thank all the participants for showing their interest in this FDP and making it grand success. Thank you all. Thank you so much, Seema ma'am.
Thank you.
The house is open for you.
Thank you, Junaid. The finale of the event lies in the playing of the national anthem. So before formally finalizing the event, I would like all the dignitaries to please stand up for the national anthem.
भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
Thank you all, and thank you for this finalizing this 30-day long interdisciplinary faculty development program.